Two elderly widows have succeeded in changing laws to recognize Muslim marriages. It started with the death of Osman Harnaker in 2014, who had married both Amina and Farieda under Muslim rites. Later, to buy property, his marriage to Amina was formalized. After his death, the wives were meant to have shared his estate equally, but the deeds office did not accept his marriage to Farieda as a civil union and therefore disqualified her. This is because of a clause in the Wills Act which said that only a surviving spouse qualifies. The Constitutional Court has now confirmed that the clause should be extended to explicitly include every husband and wife of a polygamous Muslim marriage. So that's handed down in the highest court of the land today. To discuss, we're joined by the executor of the estate, Dr. Farid Musa. Doctor, thank you very much. You're not only the executor of the estate, but a law lecturer, so you can explain what this all means. Firstly, the Constitutional Court ruling today, congratulations. What does it mean?
Thank you very much. Yes, what the judgment means is that firstly, for the surviving spouses, the property can now be registered in the names of both spouses, both the spouse that was married to the deceased in terms of South African law, as well as the third applicant to whom he was married only by Sharia. What it also means is that the Constitutional Court has today recognized that spouses in Muslim marriages are vulnerable persons, and that their vulnerability is precisely linked to the fact that there is no legislation currently which recognizes Muslim marriages.
I must say, this is all new to me. I thought that there was a recognition of customary marriages and that included religious marriages. So you're saying for all this time in our democracy, anybody married under Sharia rights has been excluded?
Indeed, sir. What you must understand is that the particular provision in the Wills Act, Section 2C, subsection 1, predates our constitutional democracy. When that particular provision was enacted in 1992, only monogamous unions were actually recognized, which is the reason that the particular provision only refers to a surviving spouse. It in fact provides that when a surviving spouse and a descendant of the deceased are both entitled to inherit from the deceased estate, and the descendants of the deceased renounce their benefits, then under those circumstances, the benefits fall back onto the surviving spouse. However, what it did not envisage was that there may be spouses who are married by polygamous unions. And because polygamy was unlawful under our pre-constitutional era, Parliament at that time only made provision for spouses in the singular and not spouses in the plural. And when the deceased, Mr. Harnaker, died in 2014, and in 2016, the registrar of the deeds office refused to actually allow registration to go into the name of the second spouse. We challenged that decision on the basis that the provision in the Wills Act that only recognizes monogamous unions was in fact an unlawful provision, as it violated both the Equality Clause and the Dignity Clause of the Constitution.
Are you saying it was a specific circumstance because the children wanted to pass it on to the mothers, or is there a general acceptance now that there needs to be more protection for people in Muslim marriages?
In fact, it does provide now for broader protection, because the particular provision in the Wills Act is a common provision which actually applies. It commonly occurs that heirs in a deceased estate renounce benefits. And where we have, as in our country, a substantial amount of the Muslim community married in terms of polygamous unions, there are potentially heirs who will renounce benefits, and that those benefits should ordinarily go to the surviving mothers of those children. Now they can in fact ensure that if they renounce their inheritance, even if the deceased was married to 2 or 3 or 4 women, each of those women would be entitled to their fair share of the deceased estate.
All right,
It would not only go to one of the spouses.
What is the response of the women themselves? And the Constitutional Court has said the law should change, but presumably that's a very long process. So does it help them at all now?
At the moment, there is a case in the Western Cape High Court, in fact, where the Women Legal Centre has brought an application which is currently being deliberated on by 3 judges in the Western Cape High Court. They've in fact challenged the minister to bring the Muslim marriage bill before Parliament. The minister and various interested parties have actually opposed that particular application. I believe that with the judgment in the Constitutional Court today that expressly recognizes the fact that Muslim women are vulnerable persons precisely because of the non-recognition given to their marriages under South African law, I believe that this now provides justification for the court to potentially rule in favor of the application, and that the court should order the minister to bring the Muslim marriage bill before Parliament.
Does this raise any other issues, other people who need to be protected, Jewish marriages, Hindu marriages? Presumably all African polygamous marriages are protected under customary law at the moment.
Indeed, insofar as African customary law marriages are concerned, the court today made it clear that part of the reason that renders the provision of the Wills Act unconstitutional is precisely because under our law, polygamous marriages under African customary law are accorded equal recognition under the law, and the court felt that there is no reason why Muslim marriages, which is similarly polygamous, should not be accorded equal status under the Wills Act. Insofar as concerns Jewish marriages, those particular marriages are obviously also not specifically regulated under legislation, and this particular judgment paves the way for Jewish spouses also to bring similar cases to the South African courts, and with this judgment will indeed succeed.
All right, thank you very much for your time. From Cape Town, the executor of the Harnaker estate, Farieda Musa.
Thank you very much.